Hello, True Crime Stories family. Welcome. Prosecuting Alex Murdaugh wasn't cheap. The South Carolina Attorney General's office confirmed that it spent $264,316.68 on housing, witnesses, travel, and other materials to successfully prosecute Murdoch for the deaths of his wife and son. Taxpayers footed the bill, but a Columbia area watchdog is calling for Alex and future convicted defendants to pick up the tab for their prosecutions. Former 11th Circuit prosecutor and current defense attorney Jim Huff said a non-death penalty trial in South Carolina usually runs 3 to 5 days. He said multiple on-scene witnesses or a case based on circumstantial evidence can drag out a trial. However, there are times when prosecutors can drag out a trial with too much evidence. Prosecutors sometimes feel that anybody that touched the case that knew anything, they just got to put everything into the recipe, so to speak, to bake a cake. Sometimes they just don't know when to stop, he said. The vast majority of Alex's prosecution expenses were for lodging, but the largest single expense went to California-based Park Dietz and Associates. The state paid the forensic consulting firm $37,840. The spreadsheet describes the expense as professional services and expenses. The firm claims to have provided experts who have testified and consulted in thousands of criminal matters, including high-profile cases. The firm did not arrange any witnesses but did consult on criminology. Another $16,100 went to witness Dr. Kenneth Kinsey for consultation and research. Kinsey played a key role in the prosecution's rebuttal of Alex's legal defense.
The defense agreed with the assessment that Paul stood there for a moment, bleeding down his injured left arm, and he slowly walked toward the door.
Okay, and what does the shooter do?
The shooter's coming in the door.
And then what does the shooter do?
He shoots Paul in the back of the head after he passes him.
Okay, and then shoots Paul in the back of the head like this, and where does the blood spatter go?
The blood spatter, the pellet defects, and one that I didn't know about that the expert collected was in the door frame at the top of the door.
Don't forget to like and subscribe. The office spent $171,044.26 at the Hampton Inn and Suites in Walterboro. That included housing for office attorneys, staff, and witness travel costs, drove up the price by $22,533.70. That included flights for witnesses, travel reimbursements for staff and witnesses, plus the rental of a 2021 Ford Explorer that was used for 11 days in January. The largest individual travel reimbursement was provided to prosecutor David Fernandez at $1,764.24 for his time between January 22nd and March 3rd. JLA Investigations and Security LLC were paid $10,769 for an expert retainer and professional services. The company specializes in digital forensics. The remainder of the costs are miscellaneous items the prosecution bought for the trial. They included poster board, maps, a book on bloodstain pattern analysis, The Attorney General's office also indicated which items were reusable and which were not. Only 0.94% of the expenses, $2,488.52, went to reusable items. A lot of the expenditures are not going to be usable in another prosecution. The witnesses against Alex can't be used to prosecute John Doe, right? All the investigative work done that was done by SLED can't be used to prosecute Jane Roe, footing the bill. Krangle argues that convicted criminals, such as Alex, should pay the costs of the investigation and prosecution through restitution. The taxpayers now are being forced to pay these costs when the criminal defendants should be required to pay them, particularly when the criminal defendants have assets that can be attached, he said. Krangle conceded defendants often lack resources, but said the issue should fall to the judge in the case. He said there could be judgments where the convicted offenders would be required to pay the costs if they obtained the money to do so. Some statutory guidelines could be formulated to give the judge a basis on which to make, or you could simply trust it to the discretion of the judge to make that determination. But I don't think it's difficult in a case like Murdoch, he said. Krangle points to the 2007 case against former South Carolina Treasurer Thomas Ravenel, who was ordered by a federal judge to pay $28,676.31 to the state of South Carolina to compensate it for the legislative session held to replace Ravenel. Former Fifth Circuit prosecutor Brett Perry and Huff both raised concerns about equal protections, a concept enshrined in the U.S. Constitution's Equal Protection Clause 14th Amendment. Perry disagreed with Krangle's argument and said the Ravenel case is a different situation. It was not a situation where Mr. Ravenel has assessed the cost of the prosecution. Believe that case was in federal court, if I'm not mistaken, and I don't believe Mr. Ravenel was ordered to pay a penny to the federal government, who absorbed the cost of prosecuting him, he said. Ravenel did not pay the court for his prosecution, but was responsible for a $221,323.69 fine. Perry also questioned where the line would be drawn. If it cost 100% of your net worth to cover the cost of your prosecution, would you take everything someone had in order to do that? He asked. Huff also strongly opposed the concept, describing it as unconstitutional. He said prosecutors would begin considering factors other than the crime and its worthiness of prosecution. Lady Justice isn't blind anymore. We're going to look at the resources of the accused. Let's go prosecute the folks that have money, not because the prosecution merits it, but we can fund our office better, he said. Krangle disagreed with the concept that the rich would face additional punishment. I don't regard it as an additional punishment. I regard it as every defendant should be required to pay restitution for their wrongdoing, whether you're judgment-proof or not. The question is, are you capable of paying it, and can it be recovered, he said. Huff said Krangle's concept also presents the opportunity for reverse enforcement. By the same token, then if the prosecution loses, they should bear all the cost to the defendant. It's not a system of justice I would want to be a part of, I can tell you that, Huff said. Krangle said he wants to see legislation on the issue, but is early in his lobbying efforts.